On the docket today, new developments in the George Zimmerman Trayvon Martin murder trial. A hearing wrapping up about an hour ago over whether to release George Zimmerman on bond. The judge not saying when he'll make a decision, suggesting that he needs time to weigh the evidence. For now, Zimmerman remains in jail. His bond was revoked, Zimmerman's, earlier this month when prosecutors told the judge that Zimmerman and his wife misled the court at the first bond hearing about how much money they had in the bank. He's charged with second-degree murder in the shooting death of 17-year-old Trayvon Martin back in February. Zimmerman claims he shot the teen in self-defense. Prosecution says he created a website for his legal defense that raised almost $150,000 and failed to mention it at the first bond hearing. But it was the focus in the courtroom today, where Zimmerman hoped to convince the judge he won't lie again. The attorneys grilled a financial forensic specialist about the money trail. Listen.
So it went from George Zimmerman to his wife to his sister, then from his sister and his wife back to George Zimmerman, and then eventually transferred to Mr. O'Mara or whatever trust they set up, correct?
Yes, sir.
Okay. So wouldn't you agree that the transfer of money to two separate accounts and then transferring after back was a way to mislead some authority if they were trying to find out how much money the person had at the time?
I wouldn't say it's to misleading, but I would say it's to make it appear that you didn't have the money.
Joining me now, Jonna Spilbor, former prosecutor, now defense attorney, and Brian Claypool, who is a defense attorney. So you saw the prosecution there trying to make the case that Mr. Zimmerman and his wife misled the court at the first bond hearing about how much money they had in the bank. And he's trying to make the case to the judge that Zimmerman cannot be trusted and should not be afforded the privilege of release pending trial. Brian, did he get the job done?
Well, I think he could have gotten the job done without any testimony from this financial consultant. I mean, Megyn, I don't know what our court systems have come to when a defense lawyer is allowed to bring in a financial forensic consultant to try to explain perjury. I mean, to me, it's clear that Mr. Zimmerman committed perjury at the initial bond hearing, and I don't think there's anything he could have done today to rehabilitate himself. So the answer is he didn't rehabilitate himself, and I think bringing on this expert makes a mockery of our court system. I really do.
John,
I mean, what happened to common sense? Where's common sense in the courtroom?
The prosecution was merciless on Zimmerman today, talking about what they believe was the blatantly misleading testimony that his wife offered at the first bond hearing about their absence of finances. Here's just a bit of that. Control room, this is soundbite number 7, if we have it.
It just wasn't a lady who walked out of the street. It was a lady who was married to him and wanted to mislead the court in terms of the amount of money that they had. They implied to the court, they told the court that they were injured, when in fact they had over $130,000. And so I would request that the court keep this defendant under no bond, because now you just don't have him committing a crime in terms of what the state has had him charged with. You now have him lying to the court through his wife, so that becomes a more egregious set of facts that makes this a more disturbing incident or crime. And therefore, I would ask the court to continue to have his bond revoked and keep him under no bond.
Jonna?
Megyn, remember in law school when our professors used to say that something was a red herring? That's what this entire bond hearing is. It's much ado about nothing. Guys, this fund was not set up so that George Zimmerman could flee the country. It wasn't set up so that he could violate his bond. It was set up so that the guy can afford to have a trial and hire a private counsel. And in fact, the money is in a third party's hands right now. He does not have access to it. Nothing else has changed. He's not a flight risk. He's no more a danger to the community than he was when the judge originally set his bond. Let the guy defend himself.
Go ahead, Brian.
That's not the issue, Jonna. The issue is whether Zimmerman can be trusted. He lied and conspired to commit perjury at the initial bond hearing. The only issue today should have been, is he a flight risk? And he clearly is a flight risk as well. He's clearly a flight risk. He was conspiring with his wife.
He's got a tracking bracelet on. He has to be in hiding because of his welfare.
Here is how his defense lawyer tried to frame the issue before the judge today. This is soundbite number 8.
Basically, yes, they didn't tell you the truth about the money. Okay. And I'm asking not to require that he now spend the next year in jail for a crime that, now that you have a better flavor for the evidence, he may well have an affirmative defense of self-defense for, and that he may well never get convicted by a jury of his peers that the state has proven this crime or any crime beyond a reasonable doubt. And I ask you not to punish him any more than you have for the fact that they did not trust you to give up, if you will, the only money that they had until 4 days later when they did.
That's the question, Jonna. Should Zimmerman have to spend essentially the next year in jail because, as his lawyer admits, he was not truthful with the court at the first bond hearing?
And his lawyer makes a really good point. Putting him back in jail was for punishment purposes. The judge has made the point. And because this turned out to be another bond hearing where we got to hear even more evidence of how innocent Zimmerman may be, that's an excellent point. If he's not going to get convicted of murder at the end of the day, and there's a good chance he won't, why should he rot in jail while he's defending himself? Excellent point.
He should rot for the next year until the trial because he had an opportunity under oath at the initial bond hearing to tell the truth. The courts look at your finances. Are you able to pay a bond? He lied in court about that. This would send a terrible message across the country to any defendant who wants to walk into a courtroom and lie in front of a judge under oath. And then later on say, hey, no problem, we'll let you go free.
We're going to carry this over after the break, because after the break I want to play the viewers some sound of the defense suggesting Trayvon Martin was killed because of his own doing. That's next.
I don't make light of it when I say that if Mr. Martin was shot because he had broken somebody's nose and he had gotten him on the ground and he had smashed his head against a cement walkway at least twice, and if you look closely at the video, maybe some other times because the side of his head looks scraped as though it went up against sandy cement, then he got shot and he was killed because of his own doing.
And there we got a little preview, Jonna, of how this is going to play out when they go either to this hearing on self-defense and stand your ground or before a jury.
Exactly, and that is the very nature of the defense. Mr. O'Mara just laid it out there for us, and that's going to be the issue here. And if it doesn't pass here, it's going to be the issue at trial.
And yet the defense, the prosecution got up there as well, Brian, and had their say as follows. Listen here, number 6.
Call that he called the non-emergency call. They told him to back off or to get back. He didn't. He runs after this person. He takes him down. And our contention is that he's the aggressor, that the person who actually has self-defense is the victim, Trayvon Martin.
There you hear the prosecution saying, in their belief, they plan to prove that he ran after Trayvon Martin, that he did not listen to the 911 operator, and that he is the one who started the confrontation.
That's it. Megyn, that's the case. The 911 tape in this case is going to seal the deal. What the prosecutor's got to do in Florida is she's got to reduce these charges from second-degree murder to a manslaughter. She's going to have trouble with second-degree murder.
She is.
Because it requires what's called requires what's called a depraved mind. We know there was a scuffle, so she's not going to be able to prove that. But what she can prove is that it was manslaughter because it's due to Zimmerman's reckless conduct. His reckless conduct here is just what the prosecutor said. Zimmerman did not heed the order from the 911 dispatch operator to not follow Trayvon Martin.
That's going to be a contention at trial.
Him.
Listen, I got to go, but I want to ask quickly. They've charged second degree, Jonna. Does the jury get charged manslaughter without something else happening?
I bet you they will. Manslaughter will be a lesser included, as we say, and so at the end of the day, he'll probably be convicted of that, even if he goes up on the murder charge.
We shall see. All right, panel, thank you so much. We'll be right back. Don't go away.